When you file an application on without notice basis, and actually when you file any application in the family courts, you're required to tell the truth, the full truth, and nothing but the truth. So what that means is you need to make full disclosures when you're doing without notice applications. So you need to disclose any criminal convictions, history of family violence, or other related things that might indicate to the courts that there's some concerns there. It's just really about giving all of the information that you can to the judge or to the court so that they can make an informed decision on that without notice platform. Kia ora tātou, kia ora anō tātou. My name is Waimirirangi. This is part 2 of the previous chat or the previous kōrero that I gave in terms of the family court, the principles and applications made under the Care of Children Act. So today I'm just going to talk a little bit about care arrangements and what happens when there is a dispute between guardians or between parents about what should happen with their children. So care arrangements naturally are things that mum and dad or parents and guardians will decide together. So you decide on who's going to care for the kids, when and where, based off of work schedules, other commitments, and that just naturally occurs between parents and guardians. Issues obviously arise when parents or guardians separate, or if there are just other views around how care arrangements should work, and then at that point you kind of want to look at what are your options to resolve that dispute. So the first piece of advice that I usually give to clients or to parties who come to me seeking advice would be to talk, which sounds really obvious, but actually having a discussion with the other parent, the other guardian or party is the first point, should be the first point. Actually trying to have a chat about the issue, see if you can reach agreement about some care arrangements. You can do that in person, you can do that via text message, Facebook message, phone call, any way essentially that you want to communicate with them, you can do whatever. If there are concerns about that approach, or if that approach is not appropriate, in some instances where it might not be appropriate is when there's too much conflict between the parties, so they're just at a point where they're like, no, can't reach agreement, we just do not see eye to eye, or if there's a lack of trust between parties or parents and guardians about what the care arrangements should be. At that point, we'd usually steer clients or parties to mediation. So in terms of family court proceedings and disputes that arise in the family court, FDR, which is Family Dispute Resolution, they manage mediation for parties in terms of those types of issues. So we'd usually refer clients to go engage in mediation. Mediation is a confidential, without prejudice process, which essentially means you can go in the room, have a chat with them, have a mediator there to facilitate that conversation, and you're not bound by anything that you talk about in that room. So nothing from that room can leave the room. It's confidential. You can't take it into an application in the courts. You can't discuss it outside of that process. The only thing that you can take out of mediation is any written agreements that you reach. So let's say you come together, you have a mediator who's facilitated mediation, and you have a written agreement you've both reviewed, or if there's more than two parties, all of you have reviewed the mediation agreement. If you're all happy with it, you sign it, and then that forms the basis of the care arrangements. Now, when clients go to mediation, I always tell them that it's really important to know that you are not required to sign anything. A mediator shouldn't be, and they're unlikely to, but they shouldn't be telling you that you have to reach agreement. If you don't feel comfortable or happy with the agreement that was reached, or if you feel pressured, or you just think, actually, I need some more time to think about this, then you are free to actually have the option to say, no, I'm not going to sign this. Mediation is a voluntary process, which means that even if you want to engage in mediation, but the other person or the other party doesn't, you can't compel them to go to mediation. So in terms of how you would start that process, you'd reach out to FDR, let them know this is the person I want to have a mediation with, and then they'll reach out to that person, and either they'll say, yep, I'm on board, let's do this, or they'll say, no, I don't want to engage in mediation. And at that point, you can usually get an exemption form, which is a form that says you tried, but they didn't want to engage. Or if you do engage and the parties or you and the other person don't reach agreement, then you'll get a form that says essentially that you went, but you didn't reach agreement. And then the third and final step available to parties is to file an application in court. So under the Care of Children Act, you can apply for a parenting order. Parenting order, or what some people kind of know it by, is a custody order. That is kind of the old terminology that we'd use. So we use the term parenting order, which pretty much just means it's an order that says who cares for the kids, and if the other party isn't the primary carer, what do their contact provisions look like? So contact provisions, or contact, is just the term that we use to say, these are the times that you get to see your mum or your dad or nanny or auntie or whoever else is applying to the courts for contact with the kids. So yeah, that's the basic functions of a parenting order. There's more details in terms of types of conditions you can include in a parenting order and provisions, but I won't get into that today. So when you do make an application for a parenting order, there are two different tracks that you can file your application. So the first track, or the most common track, is on notice. On notice just means it follows the standard process. So the requirements for filing on notice is that you must engage in mediation in FDR. You can apply to be exempt from that requirement, which is pretty much you asking the courts, hey, I know this is a requirement, but can you excuse me from having to tick this box? And they can either approve or refuse that application. And generally speaking, you would apply to be exempt from mediation if there's a history of family violence, and it wouldn't be appropriate for you to be put in a room where you're required to engage in mediation with someone where it wouldn't be appropriate for you to be engaged in mediation because there's a history of family violence, and it wouldn't be safe for you to be in a room engaging in mediation with them. The other requirement for filing on notice is to complete a Parenting Through Separation course or program, which is provided by the Ministry of Justice. It's a free program, and to the best of my knowledge, it's 4 hours long, so you can do it in person or you can do 2 sessions in 2-hour blocks, and you also have the option to do it online. And the final requirement, or the final thing that you need, is to pay the filing fee, which is $251. But you can apply to have that filing fee waived if you are suffering from financial hardship. The other option, or the other avenue available to parties when they're filing applications, is to file a without notice application. So without notice applications operate much differently to on notice applications, whereas with on notice applications you have to meet all those requirements, and then the documents are processed in court, then the other party is served, they file a response. It kind of goes through that process. With a without notice application, it bypasses all of that. Essentially, your application would be filed on the day and considered on the day, if not that day, the following working day. And the only reason, or the only way that you can apply without notice, is if you meet the grounds or the test, the legal test for filing a without notice application, which can be summed up as the legal test for filing a without notice application is that you need to be able to demonstrate to the courts that any delay in filing or processing that application would cause or would risk undue harm or hardship to the child or to the children involved in the proceedings. So what that means in practice, or in reality, is you're saying to the courts, hey, I need you to consider this ASAP, because if you don't, there's a real genuine risk that the child or the children would suffer from harm or hardship, which might look like a number of things. So it could include exposure to or ongoing exposure to family violence. It could be exposure to adult conflict, so maybe the parents are unable to reach agreement and it's gone to the point where it's escalated and the kids are constantly being dragged or pulled into adult arguments. It might look like exposure to a parent or guardian who's under the influence of alcohol or drugs, not necessarily a drink, but excessive alcohol use to the point where it becomes a risk to the kids. Other examples or other things that might give rise to a without notice application would be neglect. So if the kids are just consistently missing school or their needs aren't being met, there needs to be some sort of immediate intervention. So when you make an application on a without notice basis, like I said, it bypasses all the requirements that you need to make an on notice application. So what that means is that the right of the respondent or the right of the other parent or guardian to be heard, which we kind of understand as being natural justice, that right is removed temporarily, or the child's safety is prioritized in lieu of that right to be heard. Usually an interim order will issue, so what that means is it's just like a temporary order. It's just a placeholder while things are settled, and while the courts and other parties trying to reach agreement about what's best for the kids. When you file an application on without notice basis, and actually when you file any application in the family courts, you're required to tell the truth, the full truth, and nothing but the truth. So what that means is you need to make full disclosures when you're doing without notice applications. So you need to disclose any criminal convictions, history of family violence, or other related things that might indicate to the courts that there's some concerns there. It's just really about giving all of the information that you can to the judge or to the court so that they can make an informed decision on that without notice platform. So those are the two different options in terms of the different applications or the different tracks that you can file an application for a parenting order. It's helpful to know that it's not just mum and dad or parents and guardians who can apply for parenting orders. So wider whānau members or friends in some instances of the whānau can apply for a parenting order. If you're not the mum or the father or the guardian of the child or children, you need to seek leave of the court to file for a parenting order. So you just need to ask the courts, hey, I have an interest in making this application. Can you please allow me to make this application? And so often we see nannies, koros, aunties, uncles will come in and that they want to make an application for a parenting order to care for their niece or their nephew or their moko, because they can see that there's intervention that's needed to keep them safe, but also to keep them within the care of whānau. So yeah, that's just a little bit about how care arrangements are resolved, the approach and the options available to parties. And yeah, I think one final point that I will say is that all of the processes that we've talked about in today's chat still rely on all of the principles that were referred to in the first part of this series of kōrero, which is welfare and best interests is first and paramount consideration. So what is best for the kids or for the children? And all of the principles that we talked about, those are things that are taken into account when a decision is being made. So yeah, kia ora.